Hello, hello, hello.
And welcome to the Hildebrand Law Firm topic for today.
I'm Kirsten Hildebrand.
And I'm Matt Kaplan.
And today we're going to continue talking about that three-part series that we have going on about what exactly you need to be thinking about when something goes wrong. Because things do go wrong, don't they?
I think so, from what I've heard.
I know, and I've actually got a little example right on my very arm. Yes. It's true. Nothing was going wrong. And then all of a sudden, I was slipping and sliding down a very muddy embankment and crashed my hand against a rock.
See, that's the diplomatic story. The real story is that someone went up to Kirsten and said, Kirsten, I have all my accounts as payable on death and transfer on death. I'm going to avoid probate. And then Kirsten socked him in the
Yeah, right. I would sock the lawyer who gave that bad advice. That's for sure. Yes, so it's just interesting as we wend our way through life. There's always little reminders here and there that nothing is permanent.
No,
and nothing is above, basically being broken.
Right.
And so here I am with a broken arm for the rest of the summer. And it did make me stop and think, oh my goodness, what would happen if?
Right.
Do I have the things in order that need to be in order? And of course, my first thought was power of attorney for healthcare and finances, especially healthcare. Do I have it uploaded to my to my chart and make sure that all of that is there and that it's all in place?
Mm-hmm.
So answer was yes,
I
did, but I didn't remember that I had done it. So I needed to, definitely double check and make sure. But then the next thing that I was thinking about is what about the documents? What if I had died? What if I had hit my head on that rock, went straight into a coma and died? Then what would need to be in place if that was the situation?
Could you imagine you take up golf for a week and a half and then less than 2 weeks in, you're playing in your backyard and you end up dying? Could you imagine?
I know, right? Well, yeah, we didn't tell him that part of the story.
She was playing golf.
I was playing golf. I was picking up golf balls. So, which is actually my favorite part of the game.
It's fun.
Yeah, it is. It's really fun to pick up golf balls.
It's kind of cathartic, right?
Hot pink. They're really fun. Yeah.
But to answer your question, Kirsten, this is where wills and trusts and those form of estate planning mechanisms come into play. As to, I pass away, here's where I want all my stuff to go. Here's who I want to be in charge. Here are the specific parameters that I want, and here are the protections that I want for those individuals or organizations that I want to leave things to.
Yeah. And so what do you recommend, Matt? Is it a will? Is it a trust? Is it both? Is it neither? What are we looking at?
Well, too bad that unless you understand what you're doing, it really doesn't matter. You're just paying for a pile of papers. But if you truly understand what you're doing, you truly know what your big concerns are, and especially what kind of assets you have and how everything goes into that, then it will determine on what you need. And a lot of what plays into it is, what do you want?
Yeah,
what do you want to do?
That's a really, really good point. And that is that if you don't have good education behind what it is that you're deciding to do, you're not going to know what to do with the documents that you receive.
Right.
And it's not the easiest area of the law.
No.
It's definitely something that requires some education, some thought, and some consideration. I know that I can tell you maybe up to even 30% of people that walk into our office say, well, I thought a last will and testament meant that you don't have to go into probate.
Right. Isn't that the point?
Right, yes.
Why else do I have one?
Right. And what's the answer? The true answer is?
It's quite the opposite. Mm-hmm. A will not only doesn't prevent you from probate, a will almost guarantees a probate. A will is stating, hey, judge, here's how I want you to do my probate. Here's who I want to be in charge. Here's who I want all my stuff to go to. And so if your goal is to avoid probate and you think just having a will is going to get it done, that's where the misinformation comes into play. And what's really interesting, Kirsten, you brought up a good point about knowing the law and knowing certain things as the client end. In all the other areas of law that you've done in your life, we have never had to spend this much time educating clients on certain things.
Right.
Like when I was doing car accidents, I didn't sit my clients down and go through the 4 elements of negligence and talk about damages and all those things. No, they didn't care.
Right.
I just said, okay, here's what's going to happen in a lawsuit. I file a suit, depositions, discovery, trial, we're done.
Yeah, no, that's a great point, because when we do real estate or family law or small business law or even litigation related to estates and trusts and whatnot, we are not having to inform and educate the client about what all the elements of the law are, the various laws are, because they just want a result that's good.
Right.
But in this case, we have to teach the clients about estate planning and about the laws so that then they can make the right decisions for their family, whether they want a last will and testament or whether they want a trust, and what the implications of both of them are.
Right. Great example. And so really, to answer that question, do I need a will? Do I need a trust? We talk about this so much in these videos about what kind of assets do you have? Tell me about your family. Tell me about your goals and concerns and how that all wraps in. So Kirsten, can you give them an example of maybe a client that came in that read about trust and say, man, these trust things are great. And then after talking to them, you tell them, well, I think maybe, a trust may not be right for you. Maybe a will can get it done.
Yeah, absolutely. I have had that situation. I have had people who have had as little as $100,000 elect a trust because they knew that there would be so much family fighting that it just made it worth it to put the assets into a trust so that then they wouldn't just automatically have an open door to the courthouse and be able to air all of their complaints. Instead, the trust only went to certain beneficiaries and nobody had the legal right to see that trust because they're not heirs, they're not beneficiaries. So that is an example of where you may want to have a trust with assets as low as $100,000, and that includes a house. Now, I have certainly had situations where people come in and they have an apartment and a dog and maybe a car and a few other things, and it just doesn't seem quite appropriate, the asset level that they're at, in order for them to need a trust. And instead, it does make sense to do a last will and testament and have those assets be directed to a beneficiary. And certainly the court oversight is a very, very good idea. Another example of when it would be a good idea to have a will is kind of what I was just suggesting right there. And that is, if there really, really is nobody that you trust in your life to distribute the assets appropriately in accordance with the law, you're going to want to have the court overseeing everything. You're going to want to have a probate so that then everything flows through probate and everything is completely on the up and up.
That's a really great point. And so also, I think one small thing in which that would trigger me to think, oh, maybe a will is a really great idea if you don't have a whole lot of assets, if you have minor children.
Right. Oh, yes.
Because in a will, there's going to be a guardianship provision in there that states, if I pass away, here's who I want to take care of my kids. But anyway, for a will, oftentimes it's at least a very good idea to have the conversation about a will. If you have minor children, so you can put that guardianship provision in there. Also, usually if you have minor children, you're on the younger side. And according to probate, if you were to pass away, and let's say you don't have a spouse or your spouse passes away too, then where does everything go according to probate?
Well, it goes according to the statutes, whatever the statutes say. And so you have an opportunity to override those statutes with your will.
Yeah.
But if you choose not to, then that's what applies.
Right. Like I know for me, if something were to happen to me and my wife, my stuff would just end up going to my mom, which is fine. My mom's lovely, but I'd rather have it go to nieces and nephews.
So you would want to override that.
Right. So I'd prefer to override that.
Yeah.
Exactly.
Yeah. So let's talk about trust for a minute. So a trust is generally saying I trust that I don't need the probate court to oversee the transfer of my assets. And so instead, we're writing out our own rule book. That rule book can be pretty lengthy and really detailed and cover so much more territory than what a will can. So there's a lot of advantages. Also, you're essentially paying up front to have peace of mind for your beneficiaries because now they don't have to interact with a court case. It ends up being way more calm and just a lot smoother and simpler than the probate process. So whenever, even we have young couples come in who are maybe in their 20s, 30s, 40s, and they're just getting started, but clearly they have a really good career ahead of them.
Mm-hmm.
And let's say they've just bought a house, their first house, and they're looking to maybe start putting things into a trust. That makes all the sense in the world, because
Absolutely.
you're building that that footprint that then is going to be the same footprint that you're going to use all throughout the rest of your life, and make sure that you're putting your assets into trust.
And one common misconception about trust, especially, the theme of this video is I got diagnosed with something, what should I do? And so if your goal is, I want to avoid probate, I wanted to manage things if I ever become incapacitated, I want to have clear instructions to my loved ones after I pass and have nothing be within the purview of the courts, that a trust is a great idea. And one of the common questions that I get is, well, I'm on hospice.
Mm-hmm.
Do we really have time to create a trust?
Mm-hmm.
Yes.
Yes, as long as you're oriented to time and place,
yeah,
and you understand the objects of your bounty. And even, it's interesting, even if you were, say, hallucinating because you were dehydrated, and then you're in a lucid moment, Wisconsin says you have an absolute constitutional right to change your estate plans and to implement what you want to have implemented, so long as somebody can stand there and confirm that you are in fact in a lucid state where you are, like I said, oriented to time and place, and you understand the objects of your bounty.
But how many times, Kirsten, and this is in the level of, we've talked in videos about vertical and horizontal planning.
Yes.
This is in the world of horizontal planning. And
Mm-hmm.
how many times have you had to go to nursing homes and hospitals to get, some emergency documents like these drafted up and signed? Yeah. And so, it happens all the time, but people ask me, like, do I really need a trust? I'm on hospice, stuff like that. It's like, well, it all depends. And one of the things that I love doing is that, especially someone is on hospice, or if someone's been given a really tough diagnosis, let's get this set up. Focus on your health, focus on spending time with your family. Let's get this set up. I want to put your property in there. I want to help you put your other assets in there. And then don't worry about it. Spend the last days you have on earth with the people you love.
That's exactly right. That is very much the purpose, is to set in order and in motion all of the elements that will allow for you to then focus on what's really important in your last time here on earth. So that is the end of part 2, and we will see you for part 3.